As it was already mentioned, the first part of our meeting today will be dedicated to opposition proceedings. In this presentation, my aim is to give you an overview of the procedure in the office, of the key features and timeline of the proceedings, as well as of the legislative framework, and especially regarding the substantive grounds, the relative grounds for refusal on which the opposition can rely in the opposition proceedings. I will shortly list these grounds, and some of them I will discuss during this presentation, and one will be discussed in the subsequent presentation of today. So identity will be discussed today in this presentation, and trademarks with reputation, and likelihood of confusion will be discussed later, and I will also briefly present the other grounds. So now starting with the key features of the opposition proceedings. To put the proceedings into perspective, we have to start with the application. So after the receipt of the application, it is examined to make sure that it complies with the formality requirements, that the classification is correct, and that there are no objections on absolute grounds. And if that is all correct, or if there have been deficiencies, they have been dealt with, then the application is published. When the application is published, a 3-month opposition period begins, and within this time, third parties can file oppositions that aim to prevent the registration of the application. The purpose of opposition proceedings is to decide whether an application can proceed to registration despite the opposition from a third party. In EUIPO, on the basis of the European trademark regulation, we do not examine oppositions ex officio like absolute grounds. They are only examined upon this request from a third party, and this examination that the office carries is limited to the fact, evidence, and arguments that are presented by the parties. And these are inter partes procedure, which means that there are two parties involved, and the office respects the parties' right to be heard, right to defense. That's why, for this reason, the observations and the evidence submitted by one party are always transmitted to the other party, and the party has a possibility to comment. And finally, the proceedings can only be handled in one of the 5 languages of the office, and these are German, English, Spanish, French, and Italian. And now about the timeline. So the main milestones. Now on the presentation, on the slide, you can see the main milestones in the opposition proceedings. When the opposition is filed, and normally it is filed in an opposition notice, this is a formula that we have online, and when the opposition fee has been paid, the opposition is examined by the office to see if it is admissible, meaning to check whether all the necessary information to carry out the procedure have been presented, whether the parties have been identified, the contested sign is identified, and of course whether the area rights and the grounds have been correctly invoked. If that is the case, both parties are notified of the fact that the opposition has been filed and is admissible. And then the parties are given a time of 2 months to, we call it a cooling off period. This is the second phase. This is the time within which the parties might negotiate, maybe come to some kind of agreement, and maybe as a result, the application would be withdrawn, or the opposition would be withdrawn, or maybe the application would be limited, and that would actually then end the proceedings. However, if that is not the case, if the parties do not reach any kind of agreement, then the next phase of the proceedings begin, and this is the adversarial part of the proceedings. The adversarial part starts after 2 months of the notification of admissibility. So after the cooling off period, the cooling off period can also be prolonged up to 22 months upon request of both parties. When the adversarial part starts, this is the time when the parties make their case, they present their observations and their evidence. First, the opponent is invited to present arguments and evidence in support of the opposition, because if the opponent does not prove the existence of the other rights, then of course the opposition cannot proceed, cannot be continued. The substantiation means that the opponent has to prove that the existence of the rights on which it relies and the fact that the requirements of the grounds for refusal invoked are fulfilled. Very often the oppositions are based on registered trademarks, EUTMs, or national trademarks of the European Union. And an interesting information is that, for instance, we have so-termed online substantiation, which means that the parties can rely on information that the office can consult in the databases of the national offices. So via a portal that we have that is called TMView, we can see the information about national trademarks. And in this way, the parties can substantiate their rights. This makes the substantiation of these rights easier. Of course, there is a translation regime that still needs to be observed, but this makes the substantiation still easier. But also this is only for the international trade registrations as well as national trademarks. And EUTMs are always substantiated normally, because this is the information that the office has ex officio, because the office has the register of the European trademarks. After the opponent submitted its observations and evidence, this information is transmitted to the applicant, who has time to reply, to comment, and to defend its right. One way of defending is to ask for proof of use. Proof of use can be then requested if the trademark on which the opponent relies has been registered for over 5 years prior to the filing date of the contested trademark, of the contested EUTM application. If that is the case, if the proof of use request has been validly made by the applicant, the opponent is invited to submit evidence of use. If the opponent fails, the trademark, the area right concerned, cannot be taken into consideration. If there is no proof of use request, then the opponent is given a last opportunity to comment on the observations of the applicant, and then normally this ends the adversarial part of the proceedings. And if this part is closed, then the fourth phase of the proceedings commences, and this is the stage of decision. At the stage of decision, the office examines the case on the basis of the evidence before it and takes a decision. This decision is taken by an opposition division that consists of 3 examiners in the office. The decision is then notified to the parties, and there is an appeal period of 2 months. As the appeal can be filed to the boards of appeal of the office, and from the decision of the boards of appeal, a claim can be made to the Court of Justice, to the General Court, and then from the decision of the court, there is a possibility to appeal to the Court of Justice. So these were the proceedings, the overview of the milestones and the timeline, and now about the legislative framework that I mentioned before. So the most frequent ground that is invoked in opposition proceedings in the office is the Article 8.1, where that concerns double identity and likelihood of confusion. I will discuss double identity during this presentation, and likelihood of confusion will be discussed in a separate one, which will be the second one of today. Then we have 2 grounds that are a bit less frequent, and this is Article 8.3, that is about unauthorized filing by an agent, and Article 8.4, that is about unregistered marks and other signs used in the course of trade. I will briefly discuss these 2, as they are not that frequent, and we have limited time in this presentation. The second most frequent ground invoked is the ground 8.5 that concerns trademarks with reputation. And last but not least is Article 8.6 about geographical indications, which, as I understand, you already had a chance to hear about last week in the presentation about GIs by my colleague. What are the area rights that can be invoked in opposition proceedings? They depend on the grounds. In the grounds of 8.1 and 8.5, they can be applications or registered trademarks, EUTMs, so on the European level, or national trademarks within of the member states of the EU. They can also be international registration designating either EU or the member state, as well as well-known trademarks within the meaning of Article 8 bis of the Paris Convention. And in the Article 8.3, so the concerning the unauthorized filing by an agent, they can be registered or unregistered trademarks, and this is the only ground where trademarks from outside of EU can be invoked. Under Article 8.4, unregistered trademarks can be invoked, the ones that are used within the EU, but also other signs used in the course of trade, such as trade names, company names. And 8.6, geographical indications, as I already mentioned. So now starting with Article 8.1, double identity. Double identity of goods. I will talk now about this ground, about the double identity, and all of the of my comments about finding identity either of signs or of goods also are relevant for the assessment of likelihood of confusion under Article 8.1b, because there we also sometimes have either identical signs or goods. However, we do not have the requirement of having them both, as in this ground. This ground is a very special one because it provides for this absolute protection if these two requirements are met. It means that there is nothing else that has to be proven. The moment these two requirements are fulfilled, there is no other. And on this basis, the trademark will be the contested trademark will be refused. And also for this reason, because of this absolute protection, especially the identity of signs has to be applied strictly, which means that when we talk about the identity of signs, we talk about a situation where a trademark reproduces without any modification or addition all the elements constituting the other trademark. When it concerns word marks, it would mean that all the verbal elements, all the letters or numerals are reproduced. If it's a figurative trademark, also the figurative elements and the coloring need to be reproduced as well. So the other option is that as a whole, there are differences, but they are so insignificant that they may go unnoticed. And of course, insignificant differences, this is not a very objective concept. And also it should be applied carefully because of the consequences. So basically, insignificant differences are those that concern elements that are so small or may be lost within a complex marks that cannot be readily detected or perceived, especially by a consumer who normally does not see the two trademarks side by side. So now let's go to see particular examples, because it's always the best way to understand. Before doing that, I will only say that it's important that for word marks, the word as such is protected and not its the way it is presented. So normally depiction in lower or uppercase letters is immaterial. However, in word marks, what also has to be considered are accents or the use of punctuation marks, because they may change the perception of the signs. So now to the examples. So here we have, this was a case of the court, and we have these two trademarks, and they differ in the fact that precisely one is in the lower case letters and the other one is in the upper. And here, what the court found them to be identical despite that, because they are word marks and they they consist of the same word, and the use of capital letters does not change that. And this is an interesting example for you, because these are Cyrillic letters, and some jurisdictions within the European Union use this, for instance in Bulgaria. So for them, even though the representation is not exactly the same, but this could be considered as these insignificant differences that would not be readily perceived by the public. So these trademarks have been found identical. As I said, to find identity, all the elements of the signs should be reproduced, all the relevant elements. So here, as you can see, these two words differ in one letter. In one there is double L, in the other there is one L. That of course prevents them from being identical. In the second case, we have a hyphen. So of course, this also prevents identity. And here is a case, and now this will be a question for you. I will open a poll to engage you, and my question to you is, do you think that these trademarks are identical? I have launched a poll, so please vote. Just say yes or no. So I have so far three persons who voted. So if anyone else would like to vote, please do so. Okay, I don't seem to have any more. So of course, everyone said that the trademarks are identical, which is very interesting, and I will comment on that shortly. I will not share the results with you because these are just 3 votes and all of them mentioned. But maybe we have something in the chat, because I see that maybe there are some opinions in chat. Well, in this case, they both consist of the same word, but one is in bold typeface, in very thick letters. And for this reason, it was considered that this is a difference that will be noticed. And for this reason, they are not identical. But here, let's open another poll, and we'll keep it a bit longer so that participants have a chance to vote. Do you think that these 2 trademarks, figurative trademarks, are identical? We have very interesting results. It's 50% 50 more or less for yes and for no, so very interesting. Thank you very much for participating in the poll. Well, in this case, the difference between these 2 is the representation of this hand, because they not only differ in the exact way it is represented, but also in the fact that here there is a color. So for this reason, it was not found that these are identical. So thank you very much for participating. Here's the third one, and I will open the poll for this one as well. Okay, I am now ending the poll and sharing with you the results. So the majority said that they were identical. 17 out of 26, 9 that they are not identical. So in this case, the difference, if you look at these 2, is that, well, they're probably in the shading a bit, and also in the fact that these 3 letters, TEP, they are here in italics and here not. And in this case, it was considered that this is an insignificant difference that will not be readily perceived, so they were considered identical. So thank you very much for participating. Another interesting issue was subject to a common convergence program. That was a program of the European Trademark and Design Network, where the office and a number of trademark offices within the EU agreed on a common approach in case of earlier black and white and grayscale marks and their colored versions, to ask a question, to reply to a question if they are considered identical. And basically it was considered that if we had that, normally the differences between black and white or grayscale mark and the colored version would be noticed, so they are not identical, but they could be in exceptional circumstances if the differences in contrast or in color are insignificant. So in a similar approach as the one that I have already mentioned to you. Here do you have a link if you would like to consult this convergence program and the common practice. And this is an example that obviously in this case the trademarks are not identical, but this is an example of this exceptional circumstance where they would be considered identical, because here the difference is a bit in shading, but it's really, you need to see them side by side. And I'm not even sure if you do see the difference in the second one. I can tell you that the difference is that this the girl, she has a lollipop or a flower and it's green, but it's really small and it really is lost in these complex trademarks. So they were considered identical. So now that we have tackled the identity of signs, the other element is goods. When do we find the goods identical? The first scenario, this is the obvious one, we have the same goods, the same wording is used or is synonymous, like here. The other scenario is where we have a broader category like footwear in the area mark and the contested goods are included in it. This is also a straightforward scenario that we also find identical. Another scenario that we have in the office is the one where there is an overlap. So we have two groups of goods, neither of which is broader than the other, but they have an overlapping element. Like here, we have footwear for kids and footwear for sports, and their overlapping element is sports footwear for kids. And the office considers them to be identical as well. And the fourth scenario, which is maybe not that obvious, is when the contested goods have the broader category and the area goods are included in it. The office practice is not to artificially dissect the contested goods and on this basis to find them identical. And here are some examples for you. In this case, we have identical signs about the goods. We have data processing equipment and computers, so a very broad category. And the serial console servers are basically data processing equipment. So they were identical as well, and we have double identity. Second case, I think that by now, after all our examples, you probably already figured out that there is no double identity here because the signs are not identical. They are similar, but not identical. So that was Article 818, that was the double identity. And now let's proceed with Article 8.5. Article 8.5 is the ground for protection of reputed trademarks. And this is the text for you to consult. And now I will talk about what are the elements of Article 8.5. Article 8.5 specifically protects the other functions of the trademark, not the ones that are protected in 8.1b, likelihood of confusion, which is the identification of commercial origin. It protects the other functions like guarantee of quality of goods, advertising function, investment, particular image. So the investment of the owner of the trademark in the image of the trademark. These are the functions that are protected under Article 8.5. And also this is this enhanced protection, the protection that goes beyond the sector for which the trademark is protected as a result of its registration. It maybe goes beyond its sector as a result of this enhanced protection on the basis of reputation. So first of all, of course, we need to have a registered trademark that is reputed, and it has to be reputed within the territory for the goods. The signs have to be similar. There has to be a link. I will talk about the link because this is not a requirement that is specified in the law. It has been developed in the case law. And then on the basis of all this, we need to be able to establish that there is a risk of injury and there is no due cause. If all these conditions are met, then there will be the wide protection for the trademark and the opposition can succeed on the basis of Article 8.5. So first of all, reputation. Reputation is a degree of knowledge by a significant part of the public. It is not quantified, this knowledge. It is not set out what percentage it has to be. It has to be, in each case, it has to be assessed on the basis of the market share, intensity of use, duration, the geographical extent, the investment, and then this degree of knowledge has to be for the substantial part of the territory, be it in the member state or European Union. If it is a European trademark, it is the practice of the office on the basis of case law that normally a reputation proven in one of the member states is considered as reputation sufficient for the territory of the EU. The reputation should have been acquired before the priory date of the contested sign or the filing date, and for the relevant goods and services, of course. How can the reputation be proven? It can be proven via different means. It can be with the use of affidavits, profiles. Market surveys, opinion polls are especially good means to prove it, because they, especially if they are conducted by independent companies in an objective manner, because they provide they provide information about how the trademark is perceived by the public. It can be also proven by rankings, recognitions, awards, by press articles, turnover sales, by advertising expenditure and material, sponsorship, and also earlier decisions of the court or of the office can be invoked as well. Once we establish that we have reputation, the link. So as I mentioned, the link, this is a concept devised by the case law, by the courts. The link means that exists when the later trademark, the contested trademark, calls the earlier reputed one to mind. The link requires that there is a degree of knowledge of the earlier trademark, so that it has reputation, that the trademarks are similar. They don't have to be similar to the point of confusion, but there has to be some similarity. It also requires that there is overlap between the public, so the same consumers can perceive both trademarks, can be confronted with both trademarks, that there is some proximity of market sectors, but this doesn't have to be the similarity of goods and services that I already mentioned when I talked about the identity, and I will talk about the similarity in more detail in the next presentation. And the inherent distinctiveness of the earlier mark is also important factor. So when we take all of them into account, we establish whether such a link exists, whether the public, when confronted with these signs with regard to these goods, considering the reputation and the market sectors, would make a link between them. But of course, if there is no link, there can be no injury. If there is a link, then we have to see if there can be an injury. But first, an important part is a similarity of signs. The method of assessment of similarity is the same as 8.1b in the likelihood of confusion, and I will talk about this in the next presentation. But the standard is not the same. As I said, similarity may not be sufficient for likelihood of confusion, but may be sufficient to establish a link. This is the similarity, but if there is no similarity, there can be no link, no infringement. And when we assess the similarity, we do not take into account the reputation. Reputation is only considered at the stage of the analysis of the link and the infringement, but not similarity of signs. And here, an interesting example from the very recent case law. So this is a decision of the General Court that was confirmed by the Court of Justice. So we have these two trademarks, pear, and then you have the apple. Probably you recognize the apple symbol. And the goods and services concerned are class 9, 35, 42, basically the IT sector. And here, and at the level of the office, the opposition division and the boards of appeal found some similarity between these two signs, and on this basis established a link and found that there could be some infringement on the part of the contested sign. And here the interesting discussion was first about the visual similarity and later about the conceptual similarity. The concepts of similarity I will discuss in more detail in the next presentation about likelihood of confusion. But here, for the purposes of this case, it's interesting what the first instance mentioned was basically that there is some remote visual similarity because we have these sleek, rounded silhouettes of fruit. And conceptually, we have pears and apples, but they are closely related biologically, and they are associated with each other. So at the level of the OD and the boards of appeal, there was a similarity. And then what the court said. The court disagreed with this. The court found that we do have a depiction of different fruits, and their shapes are not the same because one has a stem and the other one has a leaf. And also one of them is solid fruit, and the other one consists of these rounded squares. And then one of them is a bitten one, and the other one has no bite. And then there is also the word element. So the court found them to be visually dissimilar. And a very interesting also part was the conceptual similarity, because here the court found that the only common element is the fact that they both concern fruit, but they are different fruits, and the public would readily see it. So the concepts that the public could associate with these two are pear with a stem versus apple with a leaf, or a full fruit versus a bitten fruit. Stem, leaf. So the existence of this generic term under which both these concepts fall, so pear and apple are both fruit, is not sufficient to make them similar. And the court found them also conceptually similar. They could not be compared orally, because the apple doesn't have any verbal element, and it is the practice normally that if there is a purely figurative signs, we consider that they cannot be compared orally. So on the basis of these two, the court found them to be dissimilar. So at this stage, then the examination stopped. 8.5 could not go further. If the signs are identical, are dissimilar, there can be no link, no injury. What are the types of injury? So after we already established that there is reputation and that there is a link, what are the types of injury? So it can be a misappropriation of attractive powers. So exploitation of this image, this prestige, taking unfair advantage. We also call it free riding. Another one is diminishing the capacity of the reputed trademark to have an immediate association with the goods. And then we call it dilution. And then the third one, this is devaluating the image that this trademark acquire among the public. So this is detriment to the repute. We call it tarnishment. And here a question to you on the basis of what I already said. We have a trademark Beatles, reputed for sound records, and then we have Beetle for wheelchairs and disability equipment. Do you think that there can be this free riding? Can one take advantage of the other? I will open a poll. So the question is, do you think that there is a free riding? I'm launching a poll. Free riding would mean that the contested trademark, the Beetle, would take unfair advantage, would profit from the attractive power of the Beatles trademark. Well, the court found that there could be free riding, that the Beatles have this image of freedom, youth, and mobility, and this image could be associated, could be attractive for the contested sign, even in the wheelchairs and disability equipment, that it could profit from this. So the court actually found that there could be a free riding here. The second case, we have a spa. It is a mineral water. There is it is reputed in the EU. It is a Belgian mineral water. The contested sign was Spa Finders, and here that sought protection for publications, catalogs, magazines. And here the court found that there was no evidence of this free riding of advantage, because also the Spa is this town of Spa, and it is also a place, and Spa also is very often associated with a place for hydrotherapy. So here, when we have Spa Finders for publications, catalogs, by the public, this can be understood more like a kind of publication. So they would not maybe make a link to the mineral water. So here the court did not confirm unfair advantage. Now about the dilution. So dilution, again, diminishing a capacity to arouse immediate association with the goods of the reputed trademark. Again, it was also in the SPA case, and here the court found that since in SPA finders, because the public will not understand SPA in the trademark sense, but as a place or a kind of place where you can have a massage or have a bath. For this reason, there would be very limited risk to the detriment of the distinctive character. Another interesting case, Botox. Botox is a trademark for pharmaceutical preparations for the treatment of wrinkles, and we have the contested sign that sought protection for cosmetic and household cleaning products, for dietetic substances, food for babies. So area that is someone not very alien to the pharmaceutical preparations, because and here the court considered that the trademarks are similar. We have Botox, Botumax, and Botox is a very fanciful term that is reputed for its treatment of wrinkles. So if such a similar term will then be used in this other area, that could dilute this reputation of the Botox trademark. And then the last example for tarnishment, we had a case with a reputed trademark Emilio Pucci for clothing, and then Emilio Tucci for not perfumed toilet paper. And here the court found that the use of Emilio Tucci, that is so similar to Emilio Pucci for the toilet paper, can cause undesired and negative association with the area mark, which acquired reputation for luxury clothing. So here the tarnishment was confirmed. So that was, ladies and gentlemen, Article 8.5, the other frequent relative ground apart from 8.1. And I will now briefly mention to you two more that are not that frequent and are a bit particular, especially Article 8.4. Article 8.4 shows this relationship within the European Union between the EU system and the national systems. There is a coexistence between the EU system of IP law and trademark law and the national system. And our EU system is based mostly on the protection of registered trademarks. So this gap and the provision of protection for the non-registered ones is is possible with the Article 8.4. This is its function, because with Article 8.4, on the basis of national rights, which still many of them protect not registered trademarks or other signs used in the course of trade, and these can be invoked in Article 8.4 precisely. The coexistence of these two systems means that neither of them has privilege. They are equal, and the conflicts, if they apply, are resolved on the basis of priority, that the earlier sign prevails. So this is the ground where non-registered trademark or other sign used in the course of trade protected under EU law or the laws of the member states can be invoked to prevent a EUTMA from being registered. Two kinds of signs here can be invoked: non-registered trademarks or other signs used in the course of trade. But it's important, they are signs used in the course of trade, so they cannot be copyrights. They cannot be personal names. They have to be signs used in the trade. And so this is the first one. The second one, they have to be used in trade, and this use has to be of a meridional or local significance. This has to be a significant use, a use that justifies granting a protection for this unregistered sign. And then on the other requirement is the requirement of the national law, that on the basis of the national law, a person has the right to prohibit use of the subsequent sign on the basis of this one. So the difficulty in these cases is that the opponent has to prove that in this national law, this kind of sign is protected, what are the requirements for this protection, and that these requirements are fulfilled in this particular case. all of this information has to be provided by the opponent to the office. This is why we don't have so many cases based on this right, and it's difficult for this case also to be successful because there are so many components. And all these conditions have to be met in a cumulative manner. Here, an example, we have unregistered trademark used in the UK on the basis invoked on the basis of passing off. And we have UTM application. You see that the signs are quite similar. The use was proven for this UK not registered trademark for these cleaners for gas turbine compressors. So we had the use, and it was proven that the use is of the Meriden-Morlocco significance within the UK. And then we knew that on the basis of passing off, the owner can prohibit use, and then the conditions of passing off had to be proven, so that there is a goodwill, the misrepresentation, and the damage. In this case, all of this was proven, at least for part of the goods. For some of the goods, it was found that they were not sufficiently similar, or services that they were not sufficiently similar to, so that there would be misrepresentation and damage. So as a result, the trademark was partially refused. But you see how many elements there were in this case. And now, also very, very briefly, the last ground, that is an authorized filing by an agent. Why do we have this ground? We have this ground so that a proprietor of a sign that is protected outside also of EU can prevent its contractor, its agent, its licensee from registering a trademark within EU. So the aim of this ground is to prevent misappropriation of a proprietor's right and its commercial interests by such applicant, so that it would not improperly benefit from the proprietor's effort and investment. The merit of this ground is to safeguard the legitimate interests of the trademark's proprietors against such agents that apply for trademarks in their own name without consent. This is a manifestation of the principle that commercial transactions should be conducted in good faith. We have also a similar ground in cancellation proceedings, and on this ground, on the basis of bad faith, trademark can be cancelled. But this ground has a narrower scope of application because there are a number of conditions, and I will briefly mention them. But first, imagine this scenario, that we have a US company that that enters European trademark and licenses the use of Gordon and Smith trademark to its distributor within EU, and then this distributor files for EUTMA in its own name. So on the basis of a treaty, this owner of this American trademark can file this opposition. If they have a protected trademark, they are the proprietor of this trademark. They show that there is an agent relationship, and if this was a distributor or licensee, this shows this kind of relationship, that there was no prior consent, and that there is no justification. And in this case, that was indeed the situation. Because if the agent, a distributor, files for the trademark in their own name, there was no consent, there is no justification, and on this basis, trademark could be refused. That's all for me. I'm sorry that I went a bit beyond what was foreseen. I hope you found it interesting, and then if you have any questions, feel free to ask them.